Sorry, I thought it was only 2 voted against, so yeah, 3.
No, there was 2. No, there was 2 to start with.
Yeah, and then Peter put his hand up.
Well, that was a waste of time for you.
Thanks, Ian. Thank you very much, guys. Right, let's move on. We have we have 1, 2, 3, 4, 5, 6 more items. You need to leave.
No, I've got to stay here. I have to leave at 5.
Okay, we'll be
I just
finished.
want to say that we've just observed the tyranny of the minority.
Yes, we have. No, it's cool.
I think it's
fine.
great.
Right, let's move on. 3. No, there was a change. There was 2 to start with, then there was 3 in the show of hands. It became 3, yeah.
Peter.
Doesn't matter. Move on. Move on, councillor. Let's go. Page 31, Environment Court decision on plan change 5. Or if I jump one there. Jump one. Page 25, Tukituki plan change 6. The update on the Board of Inquiry process. Thank you.
So just very, very briefly, councillors and talking to representatives, I've just given a brief background of the Tukituki plan change process there for you in paragraphs 2 to 6. The draft decision came out on a very narrow point, so I was getting right to the pointy end of the process, and I'm just really briefly outline what those what that decision was related to, and the matters that were there. Key matters being what exceptions might be applied to a particular rule for not requiring a resource consent, and whether we determine allocation on a sub-catchment or contributing catchment basis. The outcome of the decision was one that the council itself was comfortable with. So in terms of making comments to it, we supported the decision. There were 7 comments made in relation to plan change 6. Of which the others related to forest and bird and fish and game, just sort of minor correction to one of the policies, which is just a minor correction, so we didn't have a major problem with that. Ngāti Kahungunu Iwi Incorporated comment indicated that the decision did not align with the regional policy statement, given the change 5 decision. Just in respect of that, we note on the draft decision that the board did take into account the regional policy statement in its operative form, which was more or less consistent with what the change 5 decision was. So not quite sure where the board will end up on that one. And a few other comments from a couple of other submitters sort of pursuing sort of points that they had been unsuccessfully sort of promoting through the process. And this is their last ditch effort. So overall, in relation to change 6, my feeling is that what we see in that draft decision will be the final, more or less the final position. If that is the case, then that will report, or the plan change will come back to the council for adoption, and then it will be operative.
Questions?
When reading this particular court decision, not that I'm a lawyer.
The one before. We're on the one
plan
before.
6.
Yep.
Oh, I thought you were on plan 5.
We'll get to that.
Yeah.
We'll get there. No comment, Mr. Chairman.
Good man. So if there are no further questions... Oh, sorry, Councillor Belford.
Helen, by now you would have had an opportunity to read the HBRC submission in response to this. Could you elucidate for us what the difference is between HBRC's view of this and the regional councils?
Short answer is no, I haven't read it and I can't. So no, I haven't.
Does anyone know, Mr. Chair, sorry, does anyone know what our 100% subsidiary is saying here?
Not in relation to Plan Change 6. My understanding was that they were only commenting, and I could be wrong, but they were commenting on the draft decision around resource consent conditions on the Ruataniwha water storage consents, but not on Plan Change 6. Hence no comment here.
I've actually read their submission, and I'm not even sure that I understood it. It's so complicated, and I would like somebody to give me an interpretation. I'm really surprised that our subsidiary can do this without us knowing what they're doing.
Next week.
Next week at the regional council meeting.
Now, just before we go any further, we're not taking any recommendations here because we don't have a quorum. In fact, we could stop filming because this is not a meeting. 13.5 is a quorum. 18 of us.
75% of 18 is
12.5 or 13.5? 12.5. Okay, we still have a quorum. So we don't have a quorum.
Can I just check how many iwi tangata reps are appointed? There's 8.
I mean, Mr. Morley.
Plus Mr. Mohi.
Oh, so he's a voting member?
Oh, not a vote.
Oh, he's ex officio.
No, so there's 8 tangata.
Well, I'll ask the Chief Executive, do we have a quorum?
Yes, you do.
Excuse me, any other questions? Councillor
Mr. Chair,
Rowe.
I'm not sure who this question is, but Chief Executive, do you think it's appropriate that 100% subsidiary of the Hawke's Bay Regional Council is making a decision or of any description without first coming to this committee? We've gone through the terms of reference, and this committee should be the one that come to first. They should come to us and ask us what we're doing with our Tangata Whenua people having some say in this. At the moment, not even a council has any say in it.
Because they have their own directors, and with the deeming provision of the Act, they run their own business.
And perhaps if I could also explain, back in October 2012, I think it was 2012, this council made a deliberative decision to seek from HBRC the completion of the work to get the Ruataniwha water storage scheme up and running, including achieving the consents required. So they've given them carte blanche to work towards that end, and there's been no council resolution since then that has amended that.
And the final point is, we're talking about Plan Change 6. No, you didn't. Any other questions?
Quick question to the Chief Executive. Is there not an implied requirement for HBRC to conform with the general policies and the general attitude of its 100% shareholder? Or do they have carte blanche to do what they will on any subject at their own discretion with no reference to us?
So the decision was around the Ruataniwha water storage scheme. The decision that the council made at that time was, and still remains, in conformity with the decisions that it made at a broader level around the land and water management of the Tukituki catchment. So that includes Plan Change 6, which the council is doing, as well as a facility for water storage, which has been specifically tasked to HBRC. So they are acting in accordance with the requirements that the council has asked of them.
May I make a comment, just briefly?
might be worthwhile getting some legal advice on this, because my understanding is that a company, which HBRC is, has its own directors, as has been pointed out, has its own obligations, and is a separate legal entity. If this council was to effectively direct their decision making, this council would be deemed a director. Deemed directorship, which would then make this council liable.
We've
in
covered
relation
all
to
that.
Yeah, so I was just going to say, yeah, so that's a general principle of law that would be worthwhile clarifying so that everybody can
We've
be
had
clear.
that clarified.
Okay, just wasn't sure.
Further questions around Plan Change 6? Please. Someone happy to...
We receive this paper.
Thank you. Seconder for that. Thank you. Soptons. Further speakers you wish to speak? Mover, seconder. Put the motion. All those in favour, please say aye.
Aye.
Contrary, no. Carried. Page 51, item 11, Plan Change 5 appeal.
Chair, I'm mindful of the time, and we've still got several items to cover. There's likely to be quite a bit of discussion about this, and it's my personal view that we should be inviting Nikki as the other party to this court action to come and address us about why this was taken to court, what their views are, and how they would interpret the decision, as well as what Helen will tell us in addition to this paper.
I can answer that. They are coming to speak to us at some stage. They've had to pull out of the last meeting, but they will be here to talk about a range of issues, including this at some stage in the near future.
Yeah. Okay, so
I think we have to deal with this as a committee and get through it.
I agree we have to deal with this as a committee, but all we're going to be asked to do at the end of it is to receive the report. I think it would be more appropriate to hold the whole of the discussion when Nikki are here and we can hear what they have to say on exactly the same issue, rather than have a piecemeal approach to it by having one report now and another one in 2 months' time, especially in view of the timeframes that we're
disagree on the basis that the Regional Planning Committee won't be present at that discussion. So this is for
it should be.
Well,
I'm suggesting that should
well,
be
to line all those diaries up will be interesting, and the invitation can go out, no issue with that. But let's deal with what's in front of us today. So, anything further? Well, let's begin it then.
Excuse me, can I just apologise? I've got a flight to catch, so I need to leave in a couple of minutes, but you still have a quorum.
Okay.
If that helps.
Do you wish to lead us into this? Anything? Gavin's got it. Okay. Let's hear from Gavin first, and appreciate your time constraints. Yeah. Sure.
Okay. So, purpose of this paper was twofold. Firstly, it outlines the court's key findings in a recent decision that was issued at the end of March around 2 points in Ngāti Kahununu's appeal against Council's decisions on Change 5. And secondly, it outlined or provides some sort of commentary from where I sit, or some of us HBRC planners sit, about what those findings might mean for tank process and others in the region, and potentially also in the country. So just to put it in context, the court's recent decision, no, I'll go back a step. There were 4 appeals on Change 5. In those appeals, there were about 150 points. About 140 of those individual points have been settled by court-assisted mediation. So this recent court decision in relation to Ngāti Kahununu's appeal related only to 2 points in Nikki's appeal. There are some outstanding parts of an appeal by Hawke's Bay Fish and Game Council around wetland-related provisions in Change 5, and we're working through those. In paragraph 5, it's outlined what Nikki's appeal related to, and that was Council's earlier decision to delete Objective 21 and amend Objective 22 in the regional policy statement. So Objective 21 and 22 read pretty much as what's written in there in italics. Council's decision on Change 5, having heard submissions and whatnot, upheld what was originally publicly notified in Change 5, and that was to delete Objective 21 and slightly amend Objective 22 while doing that. And so when the council's case was put to the court in late 2014, we supported our earlier decisions. It outlined various lines of argument that there's certain implications arising from a Supreme Court ruling in New Zealand King Salmon. We wanted some statement in the RPS that the objectives that we're trying to strive for are more achievable and clearer outcome-based sorts of things. The absolute wording of no degradation pretty much made that objective impossible to achieve. And so Regional Council put its expert evidence up before the court. Ngāti Kahungunu put its expert evidence up before the court. Council's case didn't challenge the cultural expert evidence that was put forward by Ngāti Kahungunu, iwi Incorporated. So in paragraphs 9 through to whatever it is, about 16, I'll just briefly outline what the court did actually decide. And it has landed on a conclusion that RPSs and their objectives can indeed be aspirational, but confirms that there are no consequences if those aspirational objectives are not achieved. It's good enough for someone to strive to achieve those objectives. It also confirmed that existing water quality does or needs to allow for the load to come. So the load to come might be from past activities 12 months ago, 12 years ago, or over a century ago in terms of some of the groundwater lag times that we experience. So existing water quality is not just what's measured in stream today. And our case claimed that the no degradation was too absolute, and the court thought that our case overstated the issue. Basically, we thought too hard about it. The court also found that the regional council's function of controlling the use of land for purposes of maintaining and or enhancing water quality is not optional. So basically it's mandatory, whether it's easy or not. And this is one that's probably raising a few eyebrows around the country. The court did not see an overall water quality management approach allowing for unders and overs as being compatible with certain requirements in the RMA. And that's got MFE in particular tasking or asking the Crown Law Office for some legal advice about the implications of this decision. Because where MFE stand and some other commentators stand is that finding is certainly at odds with government's or cabinet's intentions when it was drafting up the National Policy Statement for Fresh Water. The court came to the conclusion that the council's interpretation of overall water quality allowing for an unders and overs approach is fundamentally flawed. That's a little bit of a ground shaking kind of finding. So I've said in my paper that from various people's perspectives who have made public comments on this decision, it's not so much about the final wording of provisions that have been reinserted into the regional policy statements. It's about the rationale that the court thought about and the reasons for coming up with what they came up with. It's the reasoning that's concerning amongst many of the commentators, not so much the wording of provisions that have been inserted back into our regional policy statement. So what's the legal effect of the court's decision? No party has appealed the Environment Court's decision, so it is or does still stand. Objectives 21 and 22, as directed by the court to be inserted into the regional policy statement, now have to be considered by future decision makers alongside the numerous other objectives and policies in the RPS. So we can't just think about objectives 21 and 22 in isolation. There will be inevitably other cases before the Environment Court, whether it's from Auckland or Bay of Plenty or the West Coast. There will be other cases relating to water quality management issues up and down the country. The Environment Court is not bound by any of its other decisions. It's free to come to its own findings in relation to the cases, individual cases before it at any particular time. So while it's a piece of case law today, at some point in the future there might be another Environment Court decision that supports this Ngāti Kahungunu decision, or there might be another Environment Court decision that finds something different. So while this decision largely reinstates the wording of objectives 21 and 22 into the RPS, by reinstate I mean these objectives have been in the RPS since about 2000, I think it was, when the RRMP was originally notified. It's certainly, from where I sit, this decision has brought those two provisions into the spotlight. Many parties are now aware of their existence, and certainly this court decision will be something that some of the parties, like those in the tank stakeholder group, will be, how shall I say, waving around to use as reasoning for them taking the stance that they're taking in the tank group discussions. But we've got to bear in mind that the court's decision in this instance related to wording in the regional policy statement. Court's decision did confirm that future regional plan changes are the appropriate forum for the